We've just received some disappointing news from the Supreme Court. They've officially declined to review two major Second Amendment cases, Snope versus Bruen and Ocean State Tactical versus Rhode Island, which challenged bans on so-called assault weapons and standard capacity magazines. This was a frustrating decision for many watching these cases closely. Let's take a closer look at what happened, what the justices had to say, and why this matters. Now, if you'd like to support the channel without spending a dime, hit that subscribe button and drop a comment below. Those simple actions help more than you know by telling YouTube that this content matters. Back to the news. The Supreme Court finally issued an order in these cases after they were relisted more than 15 times. These delays led many of us to believe that something significant might be brewing behind the scenes. But instead of granting review, the court chose to pass on both cases. These denials come even though the court has a 6-3 conservative majority, which is what makes this outcome all the more frustrating for Second Amendment advocates. From what we can tell, the decision came down to a 3-3 split among the conservative justices. Justices Thomas, Alito, and Gorsuch were in favor of granting review, pushing to take a closer look at these bans. On the other hand, it appears Chief Justice Roberts, Justice Barrett, and Justice Kavanaugh were not ready to take up the issue at this time. That group sided with the liberal justices to ultimately deny the cases. Their internal divide is reflected in the written opinions. Justice Kavanaugh issued a statement explaining the reasoning behind denying review, while Justice Thomas, joined by Alito and Gorsuch, filed a dissent, arguing why these bans deserve the court's attention. The repeated relisting of these cases likely shows there were serious discussions going on, possibly efforts to sway one of the justices, likely Barrett or Kavanaugh, toward taking up the issue. But in the end, those efforts didn't succeed. So what does this mean? It means the court has, at least for now, decided not to weigh in on state-level bans on rifles and magazines, leaving lower court decisions intact. This leaves Second Amendment challenges in a bit of limbo, and for many gun owners, this decision is seen as the court stepping back from a fight they expected it to take on. Now let's break down why Justice Kavanaugh said he agreed to deny review in this case. And then we'll go over what Justice Thomas had to say in response. In the Supreme Court's order, it simply states that the petition for a writ of certiorari is denied. Justices Alito and Gorsuch made it clear that they would have granted the petition. Following that, Justice Kavanaugh issued a statement explaining why he agreed with the denial. And on the other side, Justice Thomas wrote a dissent explaining why he believed the court made the wrong call by refusing to hear the case. In his statement, Justice Kavanaugh referenced earlier rulings, D.C. v. Heller, Bruen, and Rahimi, to explain the court's current Second Amendment framework. In Heller, the court ruled that the Second Amendment must be interpreted through the lens of the Constitution's text, history, and tradition, and emphasized that weapons commonly used by law-abiding citizens are protected under the Second Amendment. Kavanaugh acknowledged that handguns were at the center of the Heller case, and that because they were in common use, banning them was unconstitutional. He noted that this same logic still applies under the court's newer decisions and hasn't been changed by Bruen or Rahimi. Now here's where it gets important. This case specifically involves Maryland's ban on the AR-15, a semi-automatic rifle. Kavanaugh pointed out that 20 to 30 million AR-15s are currently owned by Americans, and that 41 out of 50 states allow people to own them. That makes Maryland an outlier. Given those facts, Kavanaugh said the plaintiffs have a strong argument that AR-15s are in common use and should be protected under the Second Amendment, just like handguns were in the Heller case. He even stated that it's difficult to draw a meaningful legal distinction between AR-15s and handguns. Both are semi-automatic. Both are used by law-abiding citizens for self-defense, including inside the home, and unfortunately both have been used by criminals as well. But, he noted, handguns, not rifles, are used far more often in crimes and murders in the U.S. So despite all of this, Kavanaugh still chose to deny review. Why? Because according to him, the issue is still playing out in multiple lower courts. He said that although the court is passing on the issue for now, that doesn't mean the issue is settled. He believes the Fourth Circuit's ruling is questionable, and said the First Circuit recently weighed in on the same issue, with other appellate courts considering it right now. In Kavanaugh's own words, he expects the Supreme Court will eventually take up this issue, likely within the next term or two, once the lower courts have issued more rulings. So in his view, now may not be the right time, but the court will have to confront this eventually. So that's the position from Kavanaugh's side. In a moment, we'll look at what Justice Thomas had to say in response and why he believes the court should have taken this case now. So, if we were to sum up Justice Kavanaugh and his side's stance, it would sound something like this. Yes, this is a major issue. Yes, Maryland probably got it wrong. And no, their decision doesn't line up with what the court said in Heller, Bruen, or Rahimi. But we're not going to deal with it right now. We'll let the lower courts continue to work through these kinds of cases. Maybe in a year or two we'll take it up, just not today. Now, some people might see this as a strategic move or even a sign of restraint. But for others, it feels more like an empty promise. Kavanaugh might say the court will take up the AR-15 issue in the near future, but there's absolutely no guarantee they will. If the makeup of the court shifts before that happens, say if justices like Thomas or Alito retire, then any talk about revisiting the issue could become meaningless. That's exactly the kind of concern Justice Thomas raises in his powerful dissent. He argues that by refusing to hear this case, the court is once again treating the Second Amendment like a second-class right. He warns that this inaction, along with decisions like the one in Vanderstock, is leaving law-abiding gun owners more vulnerable to federal overreach. Here's what he said directly. I would not wait to decide whether the government can ban the most popular rifle in America. That question is of critical importance to tens of millions of law-abiding AR-15 owners throughout the country. We have avoided deciding it for a full decade, and further percolation is of little value when lower courts in jurisdictions that ban AR-15s appear bent on distorting this court's Second Amendment precedents. He went on to say that if lower courts were undermining the court's precedents on any other constitutional right, the Supreme Court wouldn't stand by silently. But when it comes to the Second Amendment, that same level of urgency just isn't there. Until we are vigilant in enforcing it, the right to bear arms will remain a second-class right. And Justice Thomas made it clear that this issue is even more pressing after the court's decision in Bondi v. Vanderstock. In that case, the ATF redefined what counts as a firearm under federal law, saying it includes not just complete weapons, but even parts that could become a gun. The court let that definition stand, meaning things like unfinished parts kits are now treated the same as actual firearms. Thomas pointed out the danger in that reasoning. He warned that every AR-15 could theoretically be modified into something more powerful using just cheap, common materials, even a coat hanger. That leaves millions of lawful gun owners depending on the shifting policies of a federal agency to keep their rights intact. His conclusion was clear. This isn't how constitutional rights are supposed to work. Until the court steps in and brings clarity, AR-15 owners are left in legal limbo, without firm protection for what they believe is a core part of their self-defense rights. Justice Thomas makes it clear that by refusing to take up this case, the court is continuing to treat the Second Amendment as a second-class right. What some of the other justices are calling percolation is, in reality, just the lower courts, like the Seventh and Ninth Circuits, ignoring and twisting the Bruen decision. And as Thomas points out, there's nothing stopping them from doing it again, because the Supreme Court is simply standing by and allowing it to happen. Justice Kavanaugh, on the other hand, takes the position that everything is fine for now. He says the court may review rifle bans or magazine bans down the road, maybe in a term or two, but they're holding off for more input from the lower courts. In my view, that explanation just doesn't hold up. Kavanaugh points to ongoing cases like Angel RPC in the Third Circuit, Barnett in the Seventh, and Miller in the Ninth, cases we're already watching closely. But we already know how those are likely to turn out. So why keep waiting for decisions that will almost certainly echo what we've already seen from the Fourth Circuit? Kavanaugh also says that denying cert doesn't mean the court agrees with the lower court's decision or thinks the issue doesn't deserve review. But let's be honest, that's exactly the message it sends. Whether they intend to or not, they're signaling to lower courts that these bans can stand, at least for now. So where does this leave us? Both sides are going to claim some kind of win. Those pushing for gun control will point to the court's refusal to hear the case and argue that it supports rifle and magazine bans. Meanwhile, Second Amendment advocates will highlight parts of Thomas's dissent and Kavanaugh's statements to argue these bans are unconstitutional. But none of that creates binding precedent. It doesn't change the law, and it leaves the lower courts free to continue doing whatever they want. In the end, until the Supreme Court steps in and actually takes up one of these cases, nothing will change. That's the reality of what just happened with the rifle and magazine ban petitions. Now all the attention shifts to other pending cases like Duncan, Miller, AJRPC, and the rest. But if I'm being honest, I don't have much faith that the court will step in anytime soon. So that's where things stand. That's what was said by Justice Kavanaugh and the justices who didn't want to take the case now. And what was said by Justice Thomas, who strongly believes the court should have acted. If you have questions or want to share your thoughts, feel free to leave a comment below. I'll do my best to respond. As always, thanks for watching, and don't forget to like, comment, and subscribe.